Welcome everyone. We'll just wait a few seconds so that everyone can file into this virtual room. Find somewhere to sit. Okay, great. Well, afternoon everyone. My name's Simon Ricketts. I'm a partner at Town Legal, and I'll chair this session today, which is co-hosted by Town Legal and Landmark Chambers. There are really two purposes to the event. First of all, looking at the performance of the planning court. Has it lived up to expectations? What could be improved? What could be the future of planning litigation in the future world portrayed by the planning white paper? And secondly, a linked question as to what we make of this independent review of administrative law being carried out by a panel chaired by Lord Faulks, and in particular what it might herald for litigation in our planning law world. Indeed, is the review an opportunity to identify in some ways what might work better? I'm joined by absolutely the best panel to help us through the issues. We've kept to the rule of 6. We've got John Litton from Landmark Chambers, my fellow partner Duncan Field, Jenny Wigley from Landmark Chambers, and Tim Bewley from Landmark. A panel full of lawyers, but all with pretty different practices and views, I'm sure. So a few short housekeeping points. Obviously, your microphones are muted. We can't hear you, we can't see you, but we would very much welcome questions throughout the session through the Q&A section, which you'll find at the top or bottom of your screen. We'll try and answer questions as we go. We may not be able to answer all of them. The webinar will be recorded and you'll receive a link to the recording tomorrow so that you can watch it as many times as you like. If your connection is lost, then just rejoin using the same link. So I'm going to turn in a moment first to John to kick off with his views on the planning court, first created in 2014 as a separate list within the administrative court. From my perspective, I suppose I see 3 main advantages flowing from the planning court. First of all, the target timescales for significant planning cases, which are set down in a practice direction, both for the permission stage and the full hearing stage. Secondly, access to specialist judges experienced with the subject matter, particularly for significant cases. And thirdly, the proactive role of the liaison judge, Mr. Justice Holgate, providing direction, very direct direction, it must be said at times, to the parties to drive efficiency. And I always like to hide behind counsel at that point, I must say. This is all quite topical, given that incidentally today is the second day of a hearing in the planning court before Mr. Justice Holgate and Lord Justice Lewis, sitting as a divisional court into the challenge by a campaign group to this year's sequence of changes to the general permitted development orders. Paul Brown QC's skeleton argument for the claimants starts: can the Secretary of State, at a time when Parliament is not sitting, push through what the government itself described as the most radical changes to the planning system since the Second World War? ? Quite a opening to a skeleton argument. More prosaically, one of my frustrations for a long time with the court has been the lack of statistical data as to the number of cases it deals with, timescales and so on, which is why Duncan and I, with John and some of his colleagues, developed the Planning Court Case Explorer tool, which I hope, John, you'll also touch on. So, John, I wanted to turn to you first, maybe to open up in relation to your views on the impact on the planning system of the planning court and the reforms that were associated with it. Is it faster? Is it fairer? Has access to justice been maintained? John.
Thank you, Simon. And I'm going to reverse that, actually. I'm just going to talk about the Explorer first for a moment or two, and then I'll come to the impact of the planning court. And I mean, the Explorer very much builds on Town Legal's data visualization tool, which analyzed and broke down the data on housing appeals between 2014 and 2019 in England and Wales. And that analytical tool, which I certainly found to be extremely helpful, very interesting and very informative, led to a joint development of the Case Explorer, which takes it in a sense one step forward and says, well, you know, so many of these appeals end up in the planning court. What happens to them there? And that's really the genesis of the Explorer. And so what the Case Explorer does, and for those who aren't familiar with it, you can find it on either the landmark resource page or the Town Legal resource page. What that does is it looks at the metrics associated with all planning court cases since its inception in 2014 to second quarter of 2020. It's not perfect, but it is helpful, I think, in a number of respects. And pulling out the sort of key headlines from those metrics, you can see that there have been 493 cases in the planning court since 2014, including cases that have gone into the Court of Appeal and up to the Court of, the Supreme Court. So that if you just average that across the time period, that's about 70 cases per year. There are clearly variations in the numbers per year. There's a peak in sort of 2015 through to the second quarter of 2016. And I suspect that's attributable to the introduction of the filter stage, the requirement for permission in statutory appeals, which was introduced in October 2015. I mean, of those roughly 500 cases since 2014, about 56% have been statutory challenges, primarily Section 288 appeals, and 34% have been standard judicial reviews, again, largely of planning permissions granted by planning authorities. What's interesting is that the average time taken for cases to go from the impugned decision, so the Section 78 appeal decision or the grant of a planning permission by a local authority, to being resolved in the courts is 408 days. And you will see from the interactive tool that Mrs. Justice Lang and Lord Justice Lindblom, both as a High Court judge, but also as a Court of Appeal, have been instrumental and determined a large number of those cases. The Explorer also allows users to interrogate the case details of every case, including who the judge was, how long it took to get from the impugned decision to the date of the court's decision, the broad category of case. Town Legal's case commentary is linked through to those cases, and there are links to each and every one of those cases to the Bailey reports. So it's incredibly useful as that sort of resource as well. And certainly I'd commend it to anyone who's not familiar with it, but who perhaps wants to understand a little bit more about the judge, about the kind of cases that judge is perhaps likely to be hearing, etc., to have a look at it. And if I can, I'd just like to give a shout out really to Kimberly Zier, Nick Grant, and Alex Shattuck at Landmark, who did a lot of the sort of data crunching, and perhaps who haven't had the credit for that. So that's really about the Case Explorer. In terms of the impact of the planning court, I'm going to put my cards on the table immediately. I'm a fan of the planning court. Again, it's not perfect, but it's got to be recognized that it operates within a judicial system that is under-resourced as a whole and has to fight for its share of those resources. So the fact that we have a dedicated planning court at all, I think, is a good thing and is to be applauded. And I'd also say that I think it deserves a special mention for the way that it has stepped up in the last 6 or 7 months since March and kept going in the way that it has. And so I'm going to make a second shout out, this time to all the judges, both full-time, but also the deputies, and all the staff that have supported those judges, which has allowed planning cases to continue in that court. So why am I a fan of the court? Well, I think it is helpful to have a specialist judge who's familiar with not only the planning law, but also the practice of planning, because so many of those judges have come from the coalface in private practice. I think that is helpful both in terms of the efficiency of hearings, because you have a knowledgeable tribunal, and I think it helps in terms of the consistency of outcome as well. The second reason I'm a fan is I think the procedural measures that are operated by the planning court are generally good. I think the existence of target timescales, not just for significant planning cases, but also for all planning cases, is helpful. And I think that the designation of certain cases as significant is particularly helpful. And it has helped to get cases heard within a reasonable period of time. Now, clients will always say that they want their decisions heard and determined quicker than they are determined. But I think on the whole, the time scale taken for determination in the planning court of planning cases is pretty impressive. And the third reason I'm a fan is I think that the operation of the planning court in the regional centres, again, is a big advantage of that court. That's not to say, as I say, that this is a perfect system, and I do have some criticisms. I hope intended, well, certainly intended, I hope, to see it received in a constructive way. The first is, and I know that this is not something that is new, and I know that it is something that the planning court is aware of, but probably the planning court doesn't have a great deal of leverage. But it's this, that it's all very well having timeframes, target timescales for determination in the planning court. But when those cases are appealed, and when people ask for permission to appeal to the Court of Appeal, it hits the buffers. My personal experience is that it can take many, many months simply to get a decision on whether a case should be granted leave to appeal, and then many more months after that. And I say that's not the planning court's fault, but there is clearly an inconsistency between a regime that seeks to fast track certain cases through the planning court, which then take many, many more months to even get a decision on permission. I think some greater flexibility when it comes to listing is perhaps something to be looked at. I mean, I think hearing windows are great, but sometimes the drive to have a case determined within the target timescale is contrary actually to the administration of justice. So I think perhaps planning court needs to be a bit more selective in how it imposes those time frames. My third point is I'm getting a little bit worried about the number of rolled up hearings in planning cases. There's clearly a place for them, particularly where the matter is urgent, but it's got to be remembered the effect of a rolled up hearing is in substance to allow the claimant to bypass the permission stage. And so I think it has to be used circumspectly. One answer to that might be perhaps greater use of oral permission hearings, which are not as extensive as a rolled up hearing, but perhaps go longer than the 30 minutes or an hour that the court generally allows for an oral permission hearing. I think there has got to be greater procedural rigor by lawyers and the court in policing those procedures. And again, I would commend Mr. Justice Holgate and David Elvin QC sitting as a Deputy High Court judge in a number of recent cases. I can think of Cabeg and Buckinghamshire Council, Gladman and Secretary of State, and the Thurlow Lodge case, all within the last 6 months, where they have made the point that just because this is public law litigation does not mean that you can avoid the procedural rigor that is required in civil litigation. And sometimes I think as public law lawyers and planning lawyers, we forget that this is an aspect of civil litigation. I think the second last point is that there is a danger that of having specialist judges means that the planning court can become very, very introspective. And I welcome the introduction of some judges into the planning court who come from a non-planning background. Historically, I think of Lord Justice Hickenbottom, and perhaps more recently, Lady Justice Andrews, who I think have, put a new perspective on some of the received wisdoms, and I think it's good to question those from time to time. And the last point I want to make is I think there is and this leads into very much the sort of Faulks review, is I think there needs to be another look at automatic cost capping. I don't think it is an accident that whilst there has been a small decline in the number of cases since 2015, 2016, it hasn't been a huge reduction in the number of cases. And my suspicion is because there are now many more cases being made to the planning court because of the automatic costs regime, which favors claimants in being able to bring those cases. I don't want to go back to the old, the good old days or the bad old days of lots of satellite litigation into protective cost orders. But I think the Aarhus cost regime has got to be policed with a bit more rigor than it has been. Thank you, Simon.
Okay, John, that's really interesting. And let's pause on discussion about improvements to the system, because I know Duncan's going to come on to that. I wondered whether, Tim or Jenny, you've got any reflections on, how you feel the court's operating at the moment, whether you agree with what John is saying.
Yeah, I mean, I tend to agree. I think I'm also a fan of the planning court. I think it's efficient. It's obviously really come up to the plate in the COVID period, and like for example, I had a local plan challenge which we lodged in August last year, and we got the full hearing. Well, it was actually a rolled up hearing, but in February this year, and then we got judgment in June. And for quite a complex local plan challenge, I think that's pretty good. And just on that point about rolled up, I think there really is a place for rolled up hearings, particularly, for example, in that case where there was a lot of complex arguments and about numbers, housing numbers and things like that, which is very difficult to get across to a judge on the papers. Take your point, John, about the possibility of having a permission hearing straight away or a longer permission hearing, but when you do that, it's very difficult when you're preparing for it to treat it any less, I think, than a full hearing, because if that's your last chance, everyone puts in all the resources into it anyway, and I'm not sure really there's ever going to be much of a distinction between it effectively being a rolled up hearing or having the same amount of resource and energy and time put into it. So, but yeah, I generally agree wholeheartedly with John, I think.
I also agree with John.
No.
It's going to be like agreeing with Nick, aren't we?
David, insofar as I have to express a view,
that's never happened before.
Jenny and John on the rolled-up hearings, I think I'm slightly with Jenny. I do think they can work very well. I wanted to say something briefly, which is not so much about the planning court per se, which works, I think, really well. I mean, there's obviously the anomalies that John has talked about, but some of the associated reforms, because the planning court came in 2014, about the same time as the government introduced quite a few reforms to administrative law, which were very relevant to planning. And I just want to draw attention to what I think is one continuing anomaly. It's not the fault of the planning court, and it's not the fault of the planning judges, but it's something that the planning court has to live with, around the kind of the distinction which is still drawn in a lot of the relevant legislation between judicial review and statutory review. Because in all of those reforms, when they were introduced, whether they were the Aarhus fixed cost rules or the cost capping, which obviously made it generally easier to get cost capping orders, or the cost capping orders outside of Aarhus, which are not so relevant to planning, but generally make it harder to get cost capping orders, or the reforms about relief. So this is the introduction of the highly likely test. There's a really fundamental anomaly, I think, which as someone who's often appeared for government, I've always felt slightly embarrassed about as well as frustrated about, which is that none of those rules, they apply to judicial review, but although the Aarhus rules have now been reformed recently to address this, the others haven't. They don't apply to statutory review. And that's despite the fact that a lot of the government's justification for those reforms was precisely that, well, planning cases are causing problems, they're holding up, judges are having to grant relief on technical errors and so forth. And yet we have this bizarre situation where if you're in a statutory review rather than a judicial review, the highly likely test as a basis to refuse relief doesn't apply. Now, as I say, that's nothing to do with the planning court in the sense of being the fault of the planning judges. It's just the legislation they live with. But thinking about the reforms which accompanied the planning reforms, the legal reforms, I just think there's a real oddity there which needs to be looked at. As to the way the planning court itself manages its business, I agree. And you know, insofar as there are some limited problems, you know, that's inevitable in a system that's under-resourced. John's absolutely right about that. I've just done a case yesterday that got into court to a semi-rolled up hearing within about 3 weeks, and you know, incredible that the court was able to do that quickly. So
that's amazing. Well, Duncan, you need to break up this coziness and barristers.
It's easier for me because I'm not the one who appears before the judges, but my name might be seen on the paper somewhere, so I still need to be careful. But yeah, I mean, I think it neatly divides, I think, between before proceedings are issued and once proceedings are issued. And I think the first point I was going to make was, planning's not unique in this, but when a decision maker is challenged in planning, they tend not to be able to do anything about the decision they've taken because they've finished their function of determining a planning application or a planning appeal, and therefore there's very little they can do about it other than agree to the decision being quashed, which is a pretty dramatic outcome. And just looking at ways that could be avoided, in the sense that the decision maker is given an opportunity to review what it's doing before it issues the final decision. Seems to me there are probably at least 2 or 3 areas we could look at. The first is really nothing to do with the court at all, and just an issue of governance. Where a local authority is concerned, perhaps it should establish, as a matter of course, planning scrutiny committees to which applications are referred if a planning committee has resolved to grant planning permission in the face of objections concerning unfairness or unlawfulness. And the scrutiny committee could perhaps review the decision, send it back to planning committee with a request that those procedural irregularities are corrected, or allow it to go forward, but maybe come up with recommendations for future good practice. Taking it a stage further, both local authorities and secretaries of state could perhaps, as a matter of course, issue minded to grant decisions, which would give a sort of like a 4-week window for people to raise those sorts of issues before final decision is taken. It seems to me that's one area we could look at, in the system without really getting into whether the planning court's doing a good job or not. The other thing, I suppose, linked to that is the pre-action protocol, and in particular the fact that really, a claimant doesn't have to do anything. There's no real sanction if they don't do anything, at least in most instances, if they wait until the final planning permission is issued before challenging it. And wouldn't it be interesting if actually the protocol gave a strong guidance for claimants to issue a pre-action letter if they were going to raise points that were challengeable, immediately following, for example, the resolution to grant on planning committee. It seems to me that perhaps in planning cases, at least, the pre-action protocol could be a little stronger on that. Turning to court procedures, I think there were 2 areas I wanted to look at. First was the permission stage, and secondly was the appeals. I warn you, I haven't got many answers to the second point, but dealing with permission stage first of all, I think I'd echo a point I think you've made, Simon, that it seems a very opaque stage of the process. I mean, even if you're directly involved in the proceedings, you never really have a handle on where the application for permission to bring judicial review proceedings is. There's no publicly available database either showing you the progress of cases or even allowing you access to decisions on permission once they've been taken. And it seems to me that is one area which could be changed for the better. If nothing else, it would assist, I think, the public, let alone the lawyers, in understanding what the court is doing at that stage of the process, and in particular for claimants to see how decisions are taken on permission, because it's not an easy stage of the process to explain unless you really have been part of it or see what's going on. Secondly, I think it's a slight oddity that at a full hearing, a court is obliged to consider whether it's highly likely that the outcome of a decision would not have been substantially different, even if the conduct complained of hadn't occurred. But they don't have to do that at the permission stage. They can do that of their own volition, and I think they have to do it if the defendant raises the point. But it seems to me a slight oddity that they're not obliged to consider that at the permission stage, and therefore could refuse permission if they think, despite there being a good point, it wouldn't have made a substantial difference to the outcome. So I think that could do with tightening up, which I think would be an amendment to the Supreme Court Act. Third, the use of totally without merit. And I'm not sure when that was introduced with the reforms in 2013, 2014, how it was envisaged that would work and whether it has served its purpose. Obviously, in those cases, the judge has to conclude that a claim is bound to fail before it can declare something to be totally without merit. And the consequences of that is to deny the claimant the opportunity for an oral hearing into the question of whether permission should be given for judicial review. I think one difficulty with this is that actually, if you strip it back, the whole concept of totally without merit is a judgment call, really, surprisingly, which only a judge can make. And it's difficult to conceive of how one could try to legally or interfere with it through civil procedural rules or whatever. So perhaps the answer there is, going back to the first point, more transparency around decisions being taken, which would highlight instances of totally without merit, and maybe also guidance that might assist the parties in understanding what that means. And finally, I was going to touch on the issue of standing with some hesitation, because obviously changes to standing often bring their own problems with satellite litigation. But in planning cases, I do think it would be reasonable to require all claimants to have participated in the planning application or planning appeal process. I don't think that's too controversial. I'm sure someone's going to tell me it is, but I think that's a reasonable condition to attach to the permission stage. Final point I was going to touch on was appeals, and I think I was going to borrow from your blog, Simon, because it highlighted, following the launch of the Case Explorer, really stark statistics, and to put John's comments in detail, the difference between a case beginning in the court and a final outcome in planning court is on average 293 days. In the Court of Appeal, it's 726 days. And in the Supreme Court, it's 1,000 days, which is extraordinary and underlines the point John was making. The difficulty for us here, I guess, is that, planning is, when you compare other cases that are going through the same system and having the same problems, immigration, prison services, care services, education, etc., it's very difficult to make a special case for planning, I think. And as John said, we're probably lucky we've even got a planning court, within the administrative court. So I suspect it's a question of pooling efforts to, encourage more resourcing. But I did wonder whether there was a case, and I'd be interested to hear other views on this. Would there be a case for establishing, a liaison specialist in the same way that we had in the High Court before the Planning Court came into being, where a Lord Justice or a Supreme Court Justice could become a liaison point for planning appeals, so that they could at least cast an initial eye over it and understand what case management measures might be necessary. Those are the suggestions I had.
I think there's some provocative ideas there and some good ideas. And I was watching for Jenny's expression in particular on some of those points, which might have been said to be pro-interested party or pro-defendant. And I was conscious that, that there was one comment we've had in the Q&A is about the impacts of the costs of bringing judicial reviews, obviously a huge deterrent regardless of the cost cap. And I wondered whether you wanted to come back on any of that, Jenny.
Yeah, well, two things really. I mean, one, just going back to this point about our house. I mean, obviously the whole principle behind the our house regime is to enable people to stand up for the environment, because even though it's not in their own interests, you don't have a particular interest at risk, although some people, obviously a lot of people would say, oh yes you do, you're an NIMBY, it's also your backyard as well as the great habitats. But you know, generally that is the pure principle behind our house, that it enables people without undue risk to themselves to stand up for environmental interests. And I think that overall that's a good principle. And I think we erode it at our peril in a sort of more general kind of global sense. Secondly, one point I'd like to pick up is the Berkeley, you know, the pre-action protocol suggestion of bringing raising your points at the point of view of the resolution rather than waiting till the decision's actually granted. And you know, this isn't just an environmental claimant, you know, potentially it's quite often a developer or a neighbouring company, industrial claimant, all these sort of interested parties in the wider sense who have quite a lot of invested interests in whether this permission is granted or not. And one of the bases for the decision of the House of Lords back in whenever it was, 2000 and so, 2002, in the Berkeley decision, about whether the challenge should be brought against the decision or against the resolution, was that it's not until, obviously it's not until the decision is made that anyone's rights are affected or anything crystallizes. So to expect people, or companies particularly, to expend a huge amount of resource in scrutinising the resolution to grant, scrutinising the officer's report, when it may not ever come to be, there may be 3 years before the Section 106 is finally abandoned, if it is, or you know, or finally comes to fruition. To expect them to set out or scrutinise what possible claim they might have at that stage, and then if they don't, to be excluded from bringing a claim later, I think would be problematic. Having said that, I agree that perhaps there could be some consequences if there's something you clearly see at an early stage and then don't raise, and you are already involved, you've already been notified, it's clearly an issue, and you just hide it back. But I'd be quite happy for that to happen, a sort of consequence, but I'd be wary about cutting people off if they don't bring the challenge at the resolution to grant stage, particularly as we've now got quite a short, you know, 6-week period after the decision. It's not like a 3 months as it used to be. So that's the sort of balance I'd see from a few points that Duncan made.
Can I just add to what Jenny says on that? I can completely understand, and I've been on both sides of this, so I can completely understand Duncan's frustration with the situation where, you know, something could have been pointed out a long way ahead and you really could have sorted it out, and why shouldn't that occur? But actually, at the level of principle, I think that's quite hard for the court to do, because we're dealing with public law. So you would be requiring if the consequence is to be that they can't raise the point, then the court would have to say to itself, look, even though we think this decision is unlawful or might be unlawful, perhaps we don't decide whether it's unlawful, we're not going to quash the decision because no one raised the point earlier on. And that does create quite a fundamental difficulty in a public law context. I totally get the frustration from the defendant side when that happens. I can also see the claimant side on that, because, you know, if suppose you're an interested pressure group or something like that, do you engage lawyers three years before the decision? You probably don't. You probably get your legal advice at the end of the process, and it might be difficult to make it workable.
Just quickly, I mean, I think Duncan's point about a review mechanism at the decision stage is a good one, and certainly, I mean, in Hong Kong, it exists. So the Town Planning Board, who is the primary decision taker on planning applications, has a secondary review function, and someone who is aggrieved, who has been refused planning permission, is able to is able to ask the Town Planning Board to review its decision, and it's only on the review that then there's a statutory right of appeal. So I mean that legislation exists in other jurisdictions and does have that benefit, that if there are then points which a claimant wants to bring, that would be the time to bring it. There's an opportunity for that local authority perhaps to actually, you know, do the right thing, correct the legal error before a permission is formally issued. And that would certainly save a great deal of anxiety for those who are on the wrong end of a judicial review for what may be a planning permission, which is worth many, many millions of pounds, not just to the developer, but to the wider economy. And on the sort of the cost point, maybe I've been misunderstood. I didn't say get rid of Aarhus. I said I think it's time that perhaps people look at it again. And I mean, the suggestion that it's a deterrent, of course it's a deterrent, but you have got to look at it from both sides. And you've got to remember that the filter for getting through permission is there is simply an arguable case. That is not to say that that case is even likely to succeed. It's simply that it's arguable. And in my experience, acting both for claimants and defendants is that there are speculative claims that are brought on the basis that the cost cap means there is a relatively limited downside to the other side's costs if your speculative claim doesn't succeed. So, it does cut both ways. And again, yes, it's a deterrent to some claimants, but you've got to remember that, very often it's a public authority on the other side who do not have unlimited coffers in defending expensive claims, and they incur vast sums of public money, arguably unnecessarily.
Well, let's move on, and we then wanted to just touch on the planning white paper and the statement in the planning white paper that one of the benefits of the proposals that are set out is that the proposals should remove the risk of judicial review substantially. Most judicial reviews are about imprecise and unclearly worded policies or law. What do you think about that, Jenny? Is your career at risk as a result of the planning white paper?
I'm not quaking in my boots, Simon, I have to say. Yeah, I mean, just unpicking that. So most just judicial reviews are about imprecise and unclearly worded policies or law. I'm not sure I'd go so far as to say most. I will come back to that because there clearly are quite a lot. But obviously, it's not just about that. It's about the unintended effects of policy and law. It's about inconsistency in decision making. There's the whole remit of public law challenges which can apply, which don't necessarily be traced back to unclearly worded policies or law. But of course, that is an issue. And, we can look at the government's track record in trying to clear that issue up, can't we? About making policies simpler, more concise. And what was it in the NPPF 2012? People have been put off from getting involved because planning policy itself has become so elaborate and forbidding the preserve of specialists rather than people in communities. The NPPF changes that by replacing over 1,000 pages of national policy with around 50 written simply and clearly. We are allowing people and communities back into planning. Now that was 2012. Since then, we've had the NPPF, obviously 2019, where there's about 75 pages. And we've then got the reams of pages in the, albeit virtual pages in the PPG. But my real point is that brevity can be at the expense of clarity. And we've had pages and pages and pages of case law interpreting the NPPF, and particularly the presumption in favour of sustainable development that was in paragraph 14 and now paragraph 11. And, there's even now at the moment, I think, at least 3 High Court cases which have been granted permission to appeal to the Court of Appeal on aspects of paragraph 11. And that was an attempt to simplify planning policy and to simplify it, make it clearer, make communities find it more accessible. And instead of just looking at the policy document, they've now got to look at pages and pages of case law. That paragraph has even been described, probably wrongly, but described by, I think it was Mr. Justice Green, as an algorithm that then has had to be unpacked by its deeming provisions, its footnotes, all of that. So it doesn't inspire you with confidence that the government knows, and it's the same government, knows how to simplify, clarify, and avoid litigation on the basis of interpretation of policy. I mean, one thing that is encouraging, I think, is that at least that presumption in favour of sustainable development is proposed to be retained. Because otherwise, obviously, all that effort, all those pages of case law would now be in the bin, or would be imminently in the bin, which would be a bit of a waste. But what is perhaps more worrying is, the local plan test that's now proposed is to get rid of the soundness test and have this single sustainability test, I think it's referred to, which will have related guidance to interpret it. And the basis, I think, of that, the justification is, and I quote, the achievement of sustainable development in an existing and well understood basis for the planning system. Now, we may now think we understand the presumption in favour of sustainable development, but that doesn't actually concern the interpretation of what sustainable development actually is. And if you recall, the interpretation of that, there's a high level one about meeting the needs of the present without compromising the future, the needs of the future's ability to meet their own needs. There's that high level concept. But if you recall 2012 NPPF again, what's sustainable development? Well, in the government's view, it's policies in paragraphs 18 to 219 taken as a whole constitute the government's view of what constitutes sustainable development. Then you've got the three strands. You know, there's all these overlapping woolly concepts, which really mean what is good in planning terms, I think. I think that's really what it means. And so that's going to be the new test, which we're now going to have policy to explain. What's the betting that there's a lot of litigation about what that policy explaining what sustainable development means comes forward as litigation. So again, you know, I'm a bit concerned about that. There's another aspect of the white paper, which is this kind of lament against the fact that so many planning decisions are discretionary rather than rules-based. And I think that means that they amount to planning judgment, obviously, which we're all familiar with. But of course, planning judgment is not subject to court interference, save for in the extreme cases of irrationality or, you know, Wednesbury unreasonableness. Planning judgment is the preserve of the decision maker. If you make that more legal, more rules-based, there's a potentially much more incentive to challenge those rules in the courts, because there would be a matter of law, a strict matter of law, not just an interpretation of the policy matter. And also, because they're rule-based in terms of, you know, the intention is that they come forward in local plans, set out strict standards, set out strict rules, and then you automatically get planning permission, or you're automatically in a protection area and you don't get planning permission. That's sort of more towards sort of zoning. Once the stakes are so much higher then as to what those, you know, what those rules say, and there's no diminishment of the government's supposed aspiration to have public participation in that, which will, you know, whilst you're going to say 30 months for a local plan, if you're actually really going to define what you can have in each area by a rules-based system, and you're going to involve the public in that, you know, there's so much scope for complaint, for not being involved sufficiently, for then challenging the rules at the end of the process because of the, you know, the height of the effects that they have in terms of your rights as a developer or as a neighbour or whatever. So that's another area which I'm, you know, potentially once the rules get settled, might be easier, but, you know, I think it certainly doesn't involve court litigation, removing that planning judgment. It might remove appeals, but not court litigation. And then just one final sort of slightly miscellaneous point is one of the ideas for speeding up decision making is this possibility of making it automatic. So that if you don't get your planning application determined on a timely basis, so presumably they set a time limit, then your planning permission is automatically granted. Now that exists at the moment to some degree in prior approval in permitted development. So particularly one I've been dealing with is agricultural to residential. Put in your prior approval. If it's not determined within 56 days, you can start development, assuming you meet the headline test for prior development, for the permitted development. And of course, that has real potential problems for third parties. And in that case that I've been dealing with, Coventry Gliding Club, they've got a residential access across their runway. And they were not notified of the application. It was a site notice on a post, on a lamp post. So that's maybe something that the white paper will resolve. But they didn't see it. It was too far away, and the decision was flawed in so many ways. It didn't look at previous decisions and all sorts of things. But then also it was outside the 56-day period, we subsequently found out. And as a third party, we have no remedy, because no remedy under the Act, because, or under the regulations, because the developer has the farmer has the automatic right to proceed. And so we're having to go through, human rights litigation, which I've got coming up in November, to try and get damages under the Human Rights Act, because there doesn't seem to be any other way of getting some sort of remedy. Now, again, if you're having, you have to be careful about giving automatic planning permission when it's a public law decision. There's third parties involved, and I think there needs to be a proper mechanism for addressing that, if that is a way forward that's considered wise. So in sum, I think it's a bit hopeful to say that the proposals set out in the document will remove the risk of judicial review substantially, at least not until we get more detail on what they're actually going to be.
I hope Chris Katkowski isn't watching this.
Oh yeah, so do I.
Any thoughts before we move on?
I was just going to say that I think, just to pick up on that last point, I think if you just look at the aspirations that the government has, you can understand why they're saying what they're saying about judicial review. The problem, as Jenny says, is if as soon as you flip the concepts around into some sort of level of detail, then you can see the potential for legal challenges. And I guess that's where the government will look hard at. If it's zoning, then you're asking local authorities to get very specific on what they want to see coming forward at a point in time when they probably don't have the detail, and therefore may well make mistakes or not have the skills or resources to be as comprehensive as they should do at that stage. If you're looking at infrastructure levy, that sounds as if you're taking out a whole range of issues around is a 106 obligation necessary to make development acceptable, but actually there are other issues around, well, what happens to the money? When's it spent? When's the mitigation going to come forward that the development might need? And then perhaps just to touch on the one point that hasn't been mentioned, environmental impact assessment. The detail of that's yet to emerge, but I think the signs are they want to make it more technical and data driven as a process, which probably is an attempt to partly make it work better as an environmental assessment tool, but also perhaps to strip away some of the legal and procedural issues that have, beset the courts in terms of litigation. But again, the detail of that will be determinative of whether judicial review is closed down.
So should we widen the discussion in our final segment to look at this independent review of administrative law, which might mean everything for all of us, or it might mean nothing? I don't really have any idea. I'm slightly worried by it, both in terms of what it means more broadly for the rule of law, and also whether there might be collateral damage for our little planning corner of the legal world. But Tim, what's your view as a public lawyer?
Yeah, so this is, for those who don't know, and I'm sure some of you do, and I suspect some of you don't, this is the Faulks Review, or more formally the Independent Review of Administrative Law, the IRAL, which is going on at the moment as we speak. It reflects a Tory party manifesto commitment concerning looking at judicial review and the way that judicial review operated. But it's fair to say, I think, that it's a fairly pared down version of what they were talking about last year. It's quite an odd creature, actually, and that's one of the things I want to talk about. If you are interested in finding out more, I mean, the key documents are the IRAL terms of reference published over the summer, and then the IRAL call for evidence, which is the terms of reference set by the government, and then the panel itself issued some questions for consultation in light of that. And as I say, it's quite an odd business. I still think it's quite difficult to know what to make of it and to know what to expect. Just to give you a flavour of the terms of reference then, what are the questions? Well, I'm not going to go through them in detail in the time available, but broadly, should judicial review grounds and the basis of amenability to judicial review be codified? There's a question which is all about the government's prorogation Supreme Court case last year. Does the legal principle of non-justiciability need to be clarified? there's a question about whether, interestingly and importantly, I think the nature of the grounds for judicial review should be looked at again. That's separate from codification. And then there are some questions about procedure. Now, a couple of things to say about that. First of all, it's obviously incredibly wide-ranging. It brings within it, or at least you can see it as bringing within it, everything encompassed within judicial review in the broadest sense. And there's very limited time. There was I think it was a 6-week time for consultees to respond. It closes, I think, at the end of this week. I've been involved in the Alba response, and many others have been involved in other responses. No doubt they'll be published in due course. But what's really odd about it is there's this fundamental ambiguity, it seems to me, in the way the questions are posed, between whether what's being asked about is just about tidying up and codification and tinkering at the edges of procedural reform. And so the question is, should the grounds for judicial review be codified? Well, why not? Is it a good idea? I don't think it does achieve very much, but is it harmful? Probably not. As to whether it's really about much more fundamental change. If you just pick up the questions, you can get the impression that it's all about the tidying up. If you dig into the footnotes, I won't go into them, but there's reference to case law of the House of Lords decided as long ago as 40 years ago, whether that's really fundamental cases of establishing modern administrative law, whether they were wrongly decided. And it gets into really fundamental questions about whether judicial review took a wrong turn a very long time ago. And what that means is it's very difficult to know what to make of it. If it is that very wide-ranging reform, then the problem about timing for the decision is for any recommendations by the panel, who are supposed to report by the end of the year, becomes really fundamental, even more fundamental than I think it already is. If you look at the call for evidence, there's a slight but not very clear moving away from the kind of fundamental reform agenda and more along the lines of, and perhaps because the panel thought we don't want to bite off more than we can chew here as much as anything, we'll deal with the less controversial issues, codification, procedural reforms and so forth. Although there is also in the call for evidence a slightly worrying series of questions, and I think what's problematic about them is the way they're addressed only to public bodies, to government bodies, about, well, is judicial review, forgive me, I hope this phrase is allowed, is judicial review a pain in the bum for you? Rather than, is judicial review really important for you, or is judicial review really important for you as a private individual, a company, anyone other than a public body? And there's an agenda one imagines behind that. By the way, Lord Faulks is a former Conservative Party minister. He's also a QC, but although he didn't mainly practice in public law, it's pretty clear that his views on all of this are in line with the current thinking of the Tory party, that judicial review has gone too far. I'm not at all sure that's reflected in the other members of the panel, who are drawn from quite a wide range of things. So I don't think the outcome should be regarded as in any way a foregone conclusion. Anyway, that's what the review is. Just a couple of quick thoughts on it then, and I'll hand over to others to see what they think. The first point, obviously, is that this is not just, or even mainly, about planning or the planning court or environmental law. It reflects a government agenda, and to some extent even the government, one could almost say the culture war, about whether our courts, our elitist courts, our lefty judges, whatever you want, whatever the government wants to say about it, have overreached and they're getting in the way of government business. Very influenced by what as I've already said, the prorogation case last year about Brexit and the prorogation of Parliament. There's another case which the government is very exercised about, more technical, about ouster clauses, called Privacy International. Again, nothing to do with planning. But it does also, I think, reflect the government agenda that the courts are getting too much involved in the business of government. And if you want a poster boy case for that, maybe the Heathrow case is an example of that, notwithstanding that it might be overturned in the Supreme Court. Who knows? I'm not going to make a prediction about that. And in that respect, it becomes very important for planning. What about the, and certainly if it does result in fundamental reforms, second observation really, to the way judicial review works at the deepest level, then that's going to be a big deal. And I think what I would say about that is that then and I share Simon's thoughts about this, once you start thinking about that, you really are getting into a concern about an interference with the rule of law, because what the courts regard themselves as doing, rightly or wrongly, who knows, maybe some people think they overreach a bit sometimes, what they regard themselves as doing, what judicial review is there to do, is simply to uphold the rule of law and to make sure that public bodies, critically public bodies who exercise all these power in our modern lives, obey the law. And if we just think about the planning context particularly, you know, one can well understand why, if you're, for example, a developer or perhaps a local planning authority or indeed a central government body, you may well have a certain frustration. It's been reflected to a certain extent in some of the discussion today about the way that judicial review works. You're often on the sharp end of the wrong end of the judicial review. You're the defendant. Even if you get it dismissed, it holds up your development and so forth. But as I say, what I would say to you in that situation is, do be careful what you wish for. And without kind of giving 1,001 cases, judicial review and associated procedures in the High Court statutory review can be just as important to local authorities and to developers as they can be to claimants and NGOs and the like. I acted last year for a company who were hit with a massive SIL bill, which was wrongly £500,000, which was wrongly imposed, and the only way we got that overturned was by a claim for judicial review. Putting it on a bigger scale, think about the generic Tower Hamlets, Richard Desmond saga early in the year. That was a claim for judicial review, and now the local planning authority whose decision was being overruled by the Secretary of State, but also other rival developers in that area. It's going to be very important to them to be able to vindicate their position so that there's not a sort of cozy relationship between government bodies and certain but not all commercial entities. Two further quick thoughts. Procedural reforms, we've talked a little bit about this in the context already, in the specific context of the planning court. The IRAL is supposed to be looking at procedural issues, but I really don't think that IRAL is the right place to look at the rather planning specific procedural issues that we've been discussing, because it's looking at things on a much wider basis. If you look at the issues they're discussing, they're things which have been already sorted out to a large extent in planning. So, for example, the terms of reference pose a question about time limits. Well, you may see some time limits in non-planning JRs because of the broad brush and one-size-fits-all 3-month time limit. But I very much doubt you're going to see further reform to the 6 weeks time limits in planning cases. The one thing that could affect planning, although I think it won't affect most cases, is the possible reforms to the duty of candour and the duty of disclosure. But I mean, that's probably not a very big deal in planning. Someone who's acted often enough for defendants and so forth, disclosure is not a big deal. You've normally got a decision which sets out the basis on which the decision was taken, and the focus is always on that, and the evidence is public. So disclosure rarely an issue, and when it is an issue, it's in that sort of Tower Hamlets, Richard Desmond type case, where frankly the duty of candour is going to be critical to the court's ability to do justice, because it's only because of the duty of candour that the government was forced to concede that case. So it's a wide-ranging issue. It certainly could have massive impacts, but it's really watch this space, because we don't know what they're going to recommend. I do share Jenny's views. I know probably everyone does, that the planning reforms which we're seeing at the moment are not going to cut judicial review to the bone. We're going to see a lot of scope for judicial review, but I would be very worried if the result of these reforms meant that those judicial reviews couldn't be drawn, because there's going to be a need for the system to bed down if it's going to operate consistently, and that means that the courts have got to get involved.
Great. Well, we're approaching the end of the hour, but I don't want to cut off any final thoughts that anyone has on this, because it's such a important issue. I must say, I've taken a pretty precautionary approach, and for one business organisation, we are feeding in some thoughts about the implications for the planning system, but those thoughts may get ignored. But one of the panel members is obviously a specialist planning barrister. We shall see.
I mean, could I just say this, that I mean, I think it would be disastrous if one of the unintended consequences of reform more general to judicial review meant that the ability to challenge an entirely new planning regime was cut down, because I don't think that in the long run means that the regime that the government wants to see put in place will operate in the effective way that it should. And I think that would be a retrograde step. And I'm, in a sense, I'm pleased to see that there is, a planning barrister on that panel, hopefully making the points that Jenny has made today, for example. I think there is a wider issue about judicial review, and that is really twofold. One, it is the avenue of last resort, or possibly only resort in many cases. The kind of disputes that sometimes you see in judicial review, I mean, if those were in a private law context, they would be fought out and it would be fine, because a disappointed party would have, whether it contractual or common law right of recourse. I think the danger, and I'm pretty sure this is what has prompted the current review, is that judicial review has now been used to challenge decisions which are not just or having an effect on that particular individual, but involve these much broader macro political decisions. And I think the danger of some of the claims that have been brought is that they look at the legal errors from an incredibly narrow perspective, i.e. the perspective of the cause that they particularly espouse. And they tend to forget that those decisions are taken in a much broader context. And I suspect that is the government's frustration in terms of some of the challenges that have been brought, where the government is tasked with the responsibility of actually balancing the interests of lots of different sectors, and not simply the cause of the campaigning group or the particular individual or organization that brings that judicial review. Now, that's obviously a particular case in terms of government litigation, and not so much in terms of perhaps the more prosaic decisions in planning cases and the grant of planning permissions, etc., except when you get up to obviously the NSIPs and the like. But I mean, I think, as I say, there is a frustration in government to some of the challenges that have been brought to these much broader macro political decisions.
Well, tempting as it is to go into a really interesting second hour, I think I'll hold back.
Yeah.
I must say, I mean, I'm a legal geek, but I've done lots of these webinars over the last 6 months. But this has been the most interesting as far as I'm concerned. It's really fascinating to hear everyone's views. Tim did ask on our panelist chat function that I post a link to the Planning Court Case Explorer on the chat. I have no idea how to do that, Tim, but I've tested. And if you Google Planning Court Case Explorer, you get to either the Landmark website or the Town Legal website. So I recommend you do that. It's the Independent Review of Administrative Law. Probably if you Google that and Faulks, you'll probably get to the call for evidence. Noon on Monday is the deadline for that. And so I'll just say thanks so much for all of you for your contributions, to everyone who tuned in at home, and see you all soon. Thank you.
Bye.